The court set pursuant to Rule 22, Uniform Superior Court Rule 22 and OCGA 15-1-10.1, a hearing anticipated by 15-1-10.1 to seek input as the statute requires before entering or deciding whether or not to limit any of the proceedings. So that notice went out to all the parties concerned. And I believe that, correct me if I'm wrong, Mr. Uhowski, you and Miss, I'm trying to think of her name, who represents the media outlets. What's her?
I believe it's Leslie Gaither.
Miss Gaither, there you go. Miss Gaither, good morning, madam.
Good morning,
All right, so Miss Gaither is here. You've had discussions with her. I understand that there's a proposed order, which I have read. I believe that order, I'm going to attach as the next court exhibit in order, the proposed order. That order, I have personal knowledge of that you have forwarded to all counsel and interested parties.
That's correct.
As of a few days ago, and latest iteration of that. So at this point in time, I'll allow any defense counsels or anyone else to have input at this point in time. And under 15-1-10.1, I'm supposed to consider the nature of the proceedings at issue, the consent or objection of the parties or witnesses whose testimony will be presented in the proceedings, whether proposed coverage will promote increased public interest to the courts and openness of judicial proceedings, the impact upon the integrity and dignity of the court, the impact on the administration of justice, the impact of due process and the truth-finding function of the judicial proceeding, and whether the proposed coverage would contribute to the enhancement or distract from the ends of justice. And I'm also supposed to consider any special circumstances of the parties, victims, witnesses, or other participants, such as the need to protect children or other factors involving the safety of participants in the judicial proceeding, and any other factors that I deem as a court to be important in the circumstances of the case. The court will say for purposes of record that there have been numerous threats and other to various parties and witnesses and victims in this case, and that the order as granted or suggested balances the public's right to an open courtroom and to be able to see the proceedings, and is flexible enough for me for the court to go ahead and to fashion any additional remedies without closing the courtroom in its entirety. So, at this point, does anybody wish to be heard? Ms. Gaither, anything, madam? Okay, other than that's in the proposed order?
Correct.
And you're okay with the proposed order?
We feel the proposed order allows us on an individualized basis if there's an issue to raise it with the court, so we are.
Okay, all right. Yes, Mr. Weinstein.
Yeah, because the proposed order permits us to object to particular witnesses that are identified by the state, we don't oppose this order. Of course, under the order, we do retain the right to make objections as they come up.
Yes, sir. I would expect no less. Okay. All right, Mr. Weinstein. Anybody else? Yes, Mr. Harvey.
I just want to make sure that the understanding, and I don't know whether it's in the last order, the understanding includes us in getting the proposed list of witnesses by, it was Friday or noon on Saturday, so that we have an opportunity first thing on Mondays to come in and make our defendant's objections. Is that correct, Mr. Weinstein?
Excuse me. Yeah, we requested that a specific time and date be put in when we received the state's notice of what witnesses that they were going to list under this order. The state, I'll just say, refused to put in a specific time, saying that they had consistently provided us with those names on Friday. However, as you can see just from this past weekend, we did not receive the list until Sunday night.
I'm gonna-
We could just request, even though it's not in the order, that they provide us with the list in time so that we could respond and make any objections prior to court on Monday, so the court would be well aware and it wouldn't be sprung on the court at the last moment.
Okay. It appears that paragraph 1 indicates to address security concerns expressed by certain trial witnesses in this case, counsel for the state and counsel for immediate interveners shall consult with one another on a weekly basis to discuss the manner in which the testimony of the state's anticipated witnesses shall be recorded under Rule 22. I'm going to designate, since I'm a time-driven dude, that this needs to occur no later than Friday at 5 o'clock. Okay, Ms. Hilton and Mr. Uhalski and the state team, you all should be able to provide that, because what that does is it will allow anybody else to include your colleagues across the bar to then, over the weekend, at least kind of postulate. You all can resolve that, or I can take it up on Monday morning. So I will add that to that paragraph, or just say that you all, Mr. Uhalski, you should add that.
Can we add the defendants to that paragraph?
No, sir.
Why? Well,
It says consult with counsel for the state, counsel for the media, so account with each other. You're supposed to get that. This is just a deal with Rule 22.
I understand that, but there is a Sixth Amendment component behind this, which is why I request that we be consulted as well.
Your Honor, we're given the opportunity to object, so it would make sense in keeping the language parallel throughout the order that we also receive that list at the same time as the media interveners.
Okay.
Because we do have the right to object.
All right.
Thank you, Your Honor.
And I'm going to modify paragraph 1 as follows. To address security concerns expressed by certain trial witnesses in the case, counsel for the state, counsel for the defendants, and counsel for the media interveners shall consult with one another on a weekly basis to determine the manner in which the testimony of the state's anticipated witnesses shall be recorded under Rule 22. This shall occur by 5 p.m. on Fridays. And then the rest of it reads, for any specific witnesses for whom there are legitimate security concerns that can be substantiated by the witnesses or the state, the witnesses or the state may request that only the audio of their testimony be recorded. In addition to, for any specific alleged victims for whom there are legitimate security concerns that can be substantiated by the alleged victim of the state may request during the limited period of the live stream of such person's testimony, such person's identity to include such person's first and last name be temporarily obscured or redacted in said live stream, and that person's first and last initials only be live streamed during the limited pendency of such person's testimony. If the media interveners or any defendant objects to the witnesses, the alleged victims, or the state's request, media interveners or any objecting defendant shall be required to bring their objection to the attention of the court promptly for resolution prior to such witnesses or alleged victims' testimony. If neither media interveners nor defendant raises an objection to the witness, the alleged victim, or the state's request, or if such objection is overruled, the pool video camera and all authorized users of other cameras in the courtroom shall be instructed by the court that video or still photographic images of the witness cannot be taken while the witness is in the courtroom, or in the case of alleged victims, that person's first and last initials, only be live streamed during the limited pendency of such person's testimony, provided, however, that the live streaming or subsequent publication of recordings in which counsel, the court, or witnesses refers to alleged victims by name shall be not attributable to the media interveners as a violation of the terms of this order. In the event that a media organization streams the pool video of the trial, in this case, in conjunction with a live chat containing comments of online observers. Such media organizations shall undertake a good faith effort to remove from such chat any threatening commentary about witnesses, as well as any commentary providing identifying information regarding the witnesses, including but not limited to their purported address, phone number, current and former employer, or other sensitive personal identifiable information. 3, nothing in this order shall limit the right of the media to report on information that has already been publicly disclosed in these proceedings and is disclosed during the course of the trial or is otherwise made a matter of public record. 4, except as specifically set forth therein, nothing in this order shall limit the right of the media to record any portion of the trial of this case consistent with any Rule 22 order that has been or may enter by this court. So, Mr. Uhalski, can you make those changes? Are there any other changes I need to address?
Your Honor, on behalf of the media counsel, I just spoke this morning with Ms. Gaither, and I'll do this, and I just want to propose this on the record on their behalf. With respect to paragraph 2, we want that to apply to those who are deemed special circumstances witnesses. We don't want them exerting tons of manpower monitoring every chat for every single witness. So that limitation was proposed by media counsel. Yeah.
Thank you.
One additional change that the state and media have agreed on just as of recently was with respect to paragraph 2, in the interest that the media interveners, don't have to exert a lot of manpower monitoring all the chat for every single witness in this trial, we would suggest putting in language that paragraph 2 applies to those who have been properly deemed special circumstances witnesses only.
And what is a special circumstance witness?
Either, a victim whose initials only are to be live streamed, or a witness with, special circumstances such as like a law enforcement officer undercover, or any witness who has a legitimate request, to be audio only, not video. Basically, the 2 categories of protected sort of witnesses designated under this order.
You'll need to define that in the order, okay? Okay. That's what's going to be added.
And then
I don't have an issue with it, but it needs to be defined so everybody looking at the order knows what it means.
That'll be fine. That'll be fine. And
Good morning.
Good morning, Your Honor.
All right.
The one other request was for, we have the defendant's sort of right to object. We would like to put in there that, and I think Mr. Weinstein suggested this deadline, but a 9 a.m. deadline for them to voice any objections based on them receiving the distribution list.
Well, that's assuming you all give it to them by Friday at 5.
Well, that's exactly.
It's not aspirational.
Neither one is, yeah.
Yeah, okay, I just want you to remember that. What's good for the goose, good for the gander. If you don't give it to them by Friday at 5, then they can't expect to be enforced by Monday at 9.
That's agreeable. Understood.
So if you put that in there, I reserve the right to change or modify the time period. So, or at least for the objection to be heard. So say, for example, you don't give it to them by Friday, I got to give them an opportunity to respond to it. So I may give them a couple of days. So.
Sure.
Okay?
Thank you, Your Honor.
All right.
And just to clarify, Your Honor, that's going to be Monday morning, 9 a.m., correct? Right? Okay, thank you.
All right. Yes, add that as well. So could you can you make those changes right now and send them to counsel, please?
Yes, sir.
I think we'll have a few minutes because I don't believe our jurors are all here. Ms. Gaither, anything else, madam?
Nothing further, Your Honor.
Does that comport, or do you have any further objection to anything that the state has, or the defendants have raised thus far?
Do not, Your Honor.
Okay. Anybody else from the defense?
Your Honor, one other housekeeping matter is separate from the
Oh, if you give a mouse a cookie,
What's the other part of that?
he'll take some more. That's right. So
here we are with
right.
that. So this is just housekeeping, just as a matter of observation from watching, and I want to thank the press for their great coverage, but watching the coverage, the way that the camera is set up, you can hear a pin drop on the state's table a lot of times. And there's a lot of sort of discussion that happens at the state's table. And so that we're not just complaining with no solution in mind. We would sort of ask that we explore the option that maybe like the camera be sort of centered a little bit more to where it's not like picking up every single whisper. I mean, you can hear anything the state's attorneys are saying over here. And it's really not the case for any other parties in this proceeding. So I just wanted to put that on the record that we had a concern about.
I'll let you work on that, okay? But I'm not included to put in order at this point, okay? Because I can't control everything. That's more a media camera pick. I know that they don't, even though they could see what you're doing on your table, they don't. But if it becomes a problem, I'll certainly address it. But that's something you can talk with Ms. Gaither and the fine camera folks here, okay?
All right.
Okay?
Thank you.
All right. So, folks, we're just going to recess in place until I get the approval that all of our jurors have arrived, and then we'll go ahead and get started, okay?